You're tuned in to Agriculture Today, and we start our Wednesday show with K-State and Washburn law professor Roger McEowen discussing pesticide shield laws and litigation. Roger, thanks for joining us today.
Well, thanks for having me, Shelby.
Roger, when it comes to pesticide litigation, what has been happening?
Well, I'll tell you, 2025 was really a big year for pesticide litigation. We had massive jury verdicts across the country, and then I think even a deepening divide over whether federal law shields manufacturers from state-level lawsuits. And, you know, at the heart of this is federal law. It's the Federal Insecticide, Fungicide, Rodenticide Act, or FIFRA, and the question of federal preemption. And the basic question in all these cases is, does EPA approval of a label on a pesticide product prevent consumers from suing under state failure to warn laws? That's going to be the core issue. And really, the courts at the state level and the federal level are split on this. And the battleground state, of course, on pesticide litigation is the state of Missouri, just because of where some of the major companies are headquartered, happens to be in Missouri. But the Missouri State Supreme Court in recent years has reviewed two major cases. They upheld a $611 million judgment in one case and a $1.25 million award in another case. And they said that state warning requirements are consistent with and not different from federal standards, meaning EPA approval does not grant manufacturers blanket immunity. And that litigation really, Shelby, has gone nationwide. We've seen it in Georgia, in Pennsylvania, in the state of Washington. Particularly in Washington, the cases began flowing back from California's national multi-district litigation to the state courts in Washington state, which opens up a new front in the MDL litigation for the Pacific Northwest. And a lot of this has come from the Roundup litigation. It's just seemingly endless that Bayer, which is the successor of Monsanto, has had to deal with.
And what case has made it all the way to the Supreme Court now?
Well, that's a good question. We do have one that's before the Supreme Court. It's that $1.25 million award in a case out of Missouri. It's Durnell against Monsanto. And that case was from the Missouri Court of Appeals. It worked its way through the court system. And the Durnell case is now at the U.S. Supreme Court. They decided that they would hear the case on the 16th of January. They put it on a fast track, so we will get an opinion this term, which means by the end of June. So we'll see what happens on that one, but that's the one to watch on this issue. Last time the Supreme Court has spoken on this was known as the Bates decision. That was in 2005. So it's been 21 years, and we'll get hopefully a further clarification of the reach of Bates, and maybe this will settle down some of the state litigation too.
And is there another standard when we're thinking about Kansas that is kind of creating a clash?
Well, there's been there's been legislation in numerous states in response to these huge jury verdicts. And so in 2025, you could even go back to 2024 in Iowa, but in 2025 in particular, there was a coordinated push for state-level shield laws, and I call them shield laws. That's commonly what they're known as, to protect the ag industry from litigation. North Dakota became the first state to say that an EPA-approved label satisfies all state duty to warn requirements. Georgia passed a law limiting liability if the label is consistent with EPA health assessments. Iowa, in 2024 and 2025, the attempts to provide a blanket immunity for pesticide manufacturers failed. It stalled both times. And so those legislative actions represent a tension, I think, between protecting consumer rights to seek damages and ensuring national uniformity in chemical labeling.
And do we see a lot of consistency when we look at shield laws throughout the states?
There is some. In fact, Kansas has a bill that has actually passed the Kansas House. It's before the Kansas Senate right now. And that's often referred to, again, as a pesticide shield law. And I understand, and I think it's pretty clear to everybody that manufacturers are rightfully looking for a way out of a rock and a hard place, so to speak, created by this massive multi-district litigation. The current trajectory of the bill does raise some serious policy concerns for Kansas consumers and the integrity of the judicial system. But at its core, It's an attempt to take Kansas to the pre-2005 legal standard. Again, the Supreme Court spoke on this issue in the Bates case in 2005. And it's seeking to insulate chemical manufacturers from the type of litigation that's been successful, specifically regarding products like Roundup or glyphosate and paraquat. And so we did have a previous Supreme Court case in Kansas that's known as the Jenkins case. That was decided in 1994, but that was before the Supreme Court issued its opinion in Bates. And so essentially what the Jenkins court said in 94 in Kansas was that if the EPA approved the label, then the manufacturer's golden. They're protected. But then the Supreme Court came down in Bates and they said, no, there's no such thing as a blanket shield. And they said if state law claims are brought, those are only preempted if they impose requirements in addition to or different from the federal label under FIFRA. So if the product is misbranded, meaning the label is inadequate even by the EPA standards, then the Supreme Court, the Bates decision, allows the lawsuit to move forward. Well, what Kansas is trying to do is close that so-called Bates loophole by declaring that an EPA-approved label is sufficient as a matter of Kansas law, regardless of whether the plaintiff could prove the product is technically misbranded or that the manufacturer withheld data from the EPA. Now, it since has been amended. I'm not convinced the amendment deals sufficiently with the issue, but I do think there's a path forward to protect consumers and protect the chemical industry at the same time.
For all these factors, then, when we look at pesticide shield laws and the litigation, what are some of your concerns?
Well, I think the primary concern here is, and this is broader than just pesticide litigation, and this has to do with any type of product. We don't want manufacturers to make defective products. And if defective products are made, the legal system should hold any company responsible for making a defective product that results in injury. The problem that you've got with the pesticide issue is that the pesticide itself is usually what's defective in these situations. And so that's different than the usage of a product outside the pesticide realm. So what we've got here is some language in the amended bill that seems to still invite judges to dismiss design claims that are disguised as failure to warn claims. And in Kansas, I think there's a way to remedy that. And one, the label should be evidence of compliance, not a total shield. So we don't want to take these cases away from juries, but yet we don't want bad lawsuits being brought forth that companies have to defend. So how do we do this? Well, instead of saying that the label is prima facie evidence of compliance, in other words, you can't sue us because we've got the federal government that's blessed the label. Even the Supreme Court in 2005 didn't say that. It should be mere evidence. It should not be a total bar, not a total shield. And then what they could do in the legislation is just explicitly state that nothing in the bill limits claims for strict liability design defects or manufacturing defects, and then allow claims if the manufacturer fails to disclose known health risks to the EPA. That's an easy one. I think they will do that. I think the bill will get further amended. And then just basically codify what the U.S. Supreme Court said in 2005. Or the other thing they could do, and frankly, I think this is probably the preferred approach, let's just wait to see what the U.S. Supreme Court says in the case that's pending before it, and then model legislation after whatever the court says. That'd be the cleanest thing to do. But Shelby, you and I both know legislatures don't tend to do the cleanest thing every time.
How could this impact Kansas producers with what the U.S. Supreme Court decides?
Well, that's really where the rubber meets the road in this situation. The ag industry undeniably needs protection from predatory or inconsistent litigation. And the conclusive presumption model that's being pushed in a lot of state houses, I think, creates a dangerous precedent. So if an administrative agency becomes what I would call an impenetrable legal shield, the right to the jury of one's peers is taken away. And that doesn't just affect pesticide users. It creates a blueprint for other industries to lobby for immunity based on federal agency sign-offs. And that potentially erodes product safety concerns across the board. So for our Kansas consumers, our Kansas farmers and ranchers, we want access to these chemicals. We want a way where the companies can provide the chemicals without undue fear of litigation over them. but yet we want to protect the consumers. That's really the tough spot, the tough policy choice that legislators have to make. But that's why they're legislators. They make those tough policy choices. But we'll see what the Supreme Court says on this. And they, again, as I said, they fast-tracked it. So we'll have the decision by the end of June this year. And hopefully that finds a way where we can protect agriculture and protect consumers at the same time. Those aren't mutually exclusive goals. And I think we can find a place that satisfies everybody eventually.
Roger, what's your recommendation for people who would like to read more on this?
This is posted to my blog. It's also up on Ag Manager for K-State. I share my blog articles with Ag Manager, so that's the place they can go to find it.
Roger, I appreciate you taking the time to join us today.
Thank you, Shelby. Appreciate it.
That was K-State and Washburn law professor Roger McEowen.